Hello and welcome to the Disability Law Live Question and Answers, where we discuss issues with respect to disability law, long-term disability, short-term disability, and also other issues like life insurance and critical illness. My name is Martin Willemse. I'm a partner at the firm of Samfiru, Tumarkin, and the Western Canada Disability Practice Leader. We've got offices in British Columbia, in Alberta, and Ontario, and we handle cases throughout Canada other than Quebec. So this is a forum where we welcome questions. You can send those along to us and get responses live from me. You can ask us. You can also go to Disability Rights Questions Now. Send questions through Facebook, Twitter, and YouTube if you want. So I'll jump right into it. I've got a question with respect to critical illness, which is a bit different from long-term disability. This question comes up every now and again, and it is, what is the difference between critical illness and long-term disability? They're both insurance products that you can get. Quite often people would have it as a coverage or a benefit through their group coverage, in other words, with their employer. Or it may be that somebody who is self-employed, like a lawyer or a doctor, a psychologist, or any other business person, may go out and purchase critical insurance to cover themselves because they don't have any other coverage. The difference between the two, between critical illness and LTD, in other words, long-term disability, is critical illness is a one-time payment. They're both based on contracts. So the policy that you have with your employer or that you go out and purchase yourself, those are contracts. And they will all have rights and obligations and certain provisions. For example, with a critical illness, you are purchasing coverage that will pay out a one-time payment if you are diagnosed with a critical illness. And of course, as with everything, nothing is as simple as it sounds. Critical illness has to be a defined illness as it is defined in the policy, in other words, the contract. You may have been diagnosed with multiple sclerosis, but is it the multiple sclerosis as is defined in the contract? Is it a heart attack as is defined in the contract? Some cancers, when you think about critical illness, you would think that that would qualify, but the cancer has to meet certain criteria in order to qualify as a critical illness. Once you have that evidence that it is a critical illness, you submit a claim to the insurance company, they adjudicate it, and then they will either accept it, in other words, they will pay out the benefit, which is a one-time benefit. It's not contingent on you showing that you're unable to work. The purpose of critical illness is to cover you, or at least provide you with a sum of money if you were to be unable to work, or if you were needing lots and lots of expensive treatment that you may not have coverage for, to allow you to have that and focus on your treatment and hopefully your recovery as well. Whereas long-term disability is contingent on you proving that you are unable to work within the meaning of the policy, that you're totally disabled within the meaning of the policy. Long-term disability is a monthly payment as long as you qualify, and there are different definitions for LTD, whereas critical illness, as I said before, it's a one-time payment, and it may be up to $1 million. It could be $500,000, it could be $25,000, but it's a one-time payment. I'll speak about that further a little bit later. We have another question coming in from Missy on YouTube. Can my insurer force me to apply for CPPD? Will they cut me off if I am denied? So CPPD, just so everybody understands, is the Canada Pension Plan Disability Benefit. If you are working, or if you have been working and you've been contributing to CPP, Canada Pension Plan, you may also be able to apply for Canada Pension Plan Disability Benefits, which would be something funded by the federal government. It also has criteria, which normally would be the definition for CPP disability is you must have an illness or a condition that is both, number one, severe, number two, prolonged, and number three, that prevents you from engaging in any gainful occupation. So when insurance companies start speaking to people, insureds, that they have to apply for CPP disability, it would normally mean to me that the insurance company is looking at this, that the person making the claim may not be able to go back to work to any other occupation, which normally would happen in the any occupation phase in your policy. So going back to the question, can the insurance company force you to apply for CPPD? The reason why the insurance company is very interested and very motivated to have you apply for CPPD is because under the vast majority of group policies, the insurance company will, based on those provisions in the policy, be able to deduct the CPP disability benefit that you may receive from your long-term disability benefit. So there's a financial incentive to the insurer if you were to apply. On the other end, we would also say that if the claim were to be approved by Service Canada, in other words, your CPPD, that even the government has now accepted that you are disabled from working in any gainful occupation, which one would then want to use later on if the insurance company did deny you, saying that you cannot, that you're no longer disabled. You could also say, well, the government accepted me. But going back to the question, can they force you? So many policies will provide that even if you do not apply, the insurance company may be able to deduct it. In other words, if you do not apply, if you refuse to apply, they may say, well, we are going to estimate what the LTD, what the CPP disability benefit would be and deduct it. Will they deny you if your claim is denied by Service Canada? It's possible. I have seen cases like that where the insurance company has denied people because Service Canada has denied the CPP disability application. But as we always say in all our programs on TV, on radio, and on these live forums, if your claim were to be denied, reach out to us because we do offer free consultations. We will have a discussion with you, review your documents, review the policy if it is available, look at the denial letter, discuss your specific circumstances with you, and then give you an informed information so you can make an informed decision. As you can see on the screen, you can go to disabilityrights.ca, where we have more information as to how to contact us. And there's a vast majority of information on our website as well as to how to navigate denied cases. So if the insurance company did deny you because CPP was not successful with the application, please reach out to us so that we can discuss your options with you. We have a question from B. Wilson on YouTube. My cousin was told to go on disability leave due to his diabetes. He was denied. Is he eligible to receive short-term disability for this kind of leave? The issue with respect to a disability claim, what you have to prove is that you are functionally impaired from performing the essential duties of your occupation. So I often have questions like, can I apply for disability benefits because I have a headache disorder? Or can I apply for disability benefits because I have fibromyalgia? The diagnosis is important, yes. But the most important thing is that you have to prove that because of an illness or an injury, regardless of what the illness is, you are functionally impaired from performing the duties of your occupation. What that means is you have to get evidence, submit evidence, and quite often it will come from the doctor as well, showing what your restrictions and limitations would be. I'll use an example because the question is with respect to diabetes. There may be issues with neuropathy, right, where there may be significant pain that is difficult to control. Diabetes, there may be dizziness, there may be blurry vision. It all depends on what the impairments are, what the person's duties are, and how those impairments affect the person from performing those duties. So the short answer is most definitely yes. Your cousin can apply for short-term disability and long-term disability if your cousin is functionally impaired and has the evidence to prove that they are functionally impaired from performing the duties of their occupation. And again, as I've said before, if there were to be any issues with respect to how the insurance company is adjudicating the claim, or if it were to be denied, reach out to us because we will review the documents. I have questions weekly, and so does everybody else in my firm who handles LTD claims, or short-term disability claims, or critical illness, or life insurance. We have people contact us on a daily basis to review their contracts with them, to review the policy, to review the denial letter, to review their specific circumstances. Some people are denied because of pre-existing conditions, others because of contractual exclusions, others simply because the insurance company says you are not totally disabled, which of course you would disagree with because you applied for it in the very first instance. And I always would say to somebody, if it seems that you have a disability, there was some issue. If you have a disability, your doctor likely will be supporting you from performing the duties of your occupation. And the reason I say that is doctors complete what is called an attending physician statement to be a part of the application that you're going to submit to the insurance company. And I don't see why a doctor would complete a form if they're not supporting that you are totally disabled from working. So when you submit evidence, you would be having your evidence as well as the doctor's evidence, which may be, in this case of the diabetes situation, there may be an endocrinologist involved, there may be a family physician involved. The diabetes may have led to other issues where there may be chronic pain. It really depends on what the circumstances are. But get the best evidence that you can, submit it, and if it is denied, reach out to us and we will discuss the issue, your options with you. We've got a question from Sam Lupin. Can LTD cover long COVID issues? I've heard some people have had very serious lasting effects. Very, very good question, Sam. And I am actually quite happy that you've asked this question because, yes, we do see more cases now, especially over the last year, arising as a result of long COVID. Long COVID, I mean, obviously not everybody who gets COVID gets long COVID, but there are significant issues that people continue to have with respect to their restrictions and limitations. Long COVID, from what I have seen from cases that have been denied, the symptoms, the restrictions and limitations would often be brain fog, extreme and profound fatigue, low energy, low motivation, difficulty thinking, concentrating, focusing, multitasking, difficulty with memory, with comprehension, lots of issues like that. So there are cases that I have seen that have been approved for long COVID, but many of them have afterwards also been denied. So most definitely, yes. If long COVID is the issue, or regardless of what the issue is, because long COVID is, from what I've seen, very similar to what is called myalgic encephalomyelitis, similar to chronic fatigue syndrome, with those same symptoms. The concerns that people often have and the difficulties that they have is that it is so new that many doctors may not be aware of what is going on. It takes time to work through the medical system to get proper evidence, to get a doctor to understand what is happening. Many doctors do, and there are specific long COVID clinics, but quite often people get discharged from those clinics and then discharged back to their doctor's care. And doctors get frustrated because insurance companies do deny these cases and they are not sure then how to navigate those issues. So again, my advice, if you are denied because of a long COVID disability claim, I can say this to you now, we speak to people with this on a regular basis, I would say almost weekly, that I have a discussion with somebody who has been denied because the insurance company says it's long COVID, we don't have the evidence, we don't think that you're disabled. There are options and we can assist. So do reach out. We've got a question from Lisa Thompson on YouTube. I'm on LTD. My doctor has told me that the insurance company can contact her with any questions about my medical condition. I've emailed them multiple times to tell them this, but they are insisting on talking to me and not calling my doctor. What can I do? This is a frustrating situation because the insurance company may prefer back to their contract, the policy, which may say that you have to, I've seen this happen as well, where you have to cooperate with the insurance company. Now, what does that mean? The insurance companies do reach out to people to get updates. They call them often functional telephone interviews. If it is difficult for you to communicate with the insurance company verbally, because you may have a mental health disorder like anxiety, and it increases the anxiety to the extent that it worsens your condition, have your doctor write to the insurance company telling them how this is negatively impacting your ability to communicate and your ability to treat your condition and to improve. You may also want to tell the insurance company to communicate with you in writing so that you can respond to their emails. Ultimately, they will want to communicate with you through one or other way. If it is on a very regular basis, again, I think getting the medical evidence in place from the doctor, or rather the medical support, as to how this is negatively impacting you will assist. But ultimately, whether the insurance company is going to leave you alone and no longer contact you, I don't see that happening. They can get updates from the doctor, but they also should not be harassing you. And if that is the situation, like I've said before, reach out to us and we can discuss your specific circumstances with you, maybe get a bit more information, and then tell you what we think your options would be. We've got a question from Scott Anderson. What happens when an LTD insurance provider informs an employer that it would be highly unlikely to return to work after being on LTD for 2 years, yet haven't completed a review of medical updates? If we're speaking about a period of 2 years, this may be that the insurance company is looking at whether you are totally disabled from performing the duties of any other occupation. Disability contracts have change of definition timeframes. What that means is for the first 2 years, for the most of them, some may be 1 year, some may be 18 months, some may be 3 years, but the vast majority of them would be 2 years. So for those 2 years, you have to prove that you cannot perform the duties of your own occupation. Then the definition changes, where you have to prove that you cannot perform the duties of any other occupation, which is more difficult, obviously, because it's not limited to just working in your own job or your own occupation. It would be, can you perform the duties of any other occupation for which you have the transferable skills based on your education, your training, and your experience, and that would pay you an amount similar to your long-term disability benefit. So again, the question, what happens when an LTD insurance provider informs the employer that it is highly unlikely that you would return to work after being on LTD for 2 years, yet they haven't completed a review of the medical updates? If they're informing the employer of that, it sounds like they're looking at approving the claim into the long-term disability, into the any occupation phase. So I will say this to you. If your employer did terminate your employment because of this, it may be because of something called frustration of contract, you're still disabled from working. I would suggest, strongly suggest and advise that you contact our firm, because we also have very qualified and experienced employment lawyers who could navigate that situation with you and tell you what your options are. And if the insurance company did deny your claim, same advice as I've given everybody else, reach out to us and we can consider what options you may have. But listening to this question, or reading this question, it seems that the insurance company is looking at and maybe will be approving the claim into the any occupation phase. The reason why I say that is I wouldn't understand why they would tell the employer that you're not going to come back to work and that it is highly unlikely that you will come back to work at that 2 year time, and then deny the claim. So, but if that were to happen, because these things do happen, reach out to us. As you can see on the screen, there was go to disabilityrights.ca, and there's a vast wealth of information there, and you can contact us through that forum. We've got a question from Walter on Facebook. I have been injured. It has left me with permanent mobility issues. I would like to return to work at some point, but cannot do the same job anymore. I'm currently on LTD. What are my options? Okay, so going back, similar to the question that I just answered, you've been injured, you've got permanent mobility issues, you would like to return to work, but you cannot do your same job anymore. So hopefully the insurance company is approving your claim into what is called the own occupation phase. So those first 2 years, if it is a 2 year time frame. Then the definition changes. Then you have to prove that you cannot perform the duties of any other occupation. You would like to return to work, but what does that look like? Is it something where you've got the transferable skills to work at? Because the insurance company will be looking at that. If it is that they find, the insurance company, if the insurer finds that you, in their opinion, can perform the duties of another occupation that would pay you roughly the same as your long-term disability benefit, you're likely facing a denial. But the question is, what are your functional limitations and restrictions, and what is your capacity? Is it that you can only work 2 hours a day or 3 hours a day in another job that may be paying you a lot less than you were doing before? Then you likely will still continue to qualify for benefits. These policies have what is called rehabilitation clauses in them. Some of them also have partial disability benefits. So it is extremely important to know what the policy says, to know what the contractual provisions are. If it is that you can work and the insurance company says, well, we are now denying your claim because we think that you can work, it really depends on what that looks like. If it is you can work more than, say, 70%, earn more than 70% of what you were earning before, and you can do that within your medical restrictions and limitations, then you may not qualify for LTD benefits into the any occupation phase, but we won't know. So, Walter, I think what we would want to know is, what is your functional impairment? What is your capacity? How much can you do? What does that look like? Does it still allow you to receive long-term disability benefits? Before you make any communications to anybody, let's just have a chat about it and see what you can and what you cannot do, and always have your doctor on board, right? If the doctor agrees that you can do certain things, then you may try. And if you fail, of course, there's something called a reconsideration, so the recurrent phase in your policy. So it really depends on your factual circumstances. Email question from Samantha. My insurer is asking me to use a website called Pill Check to review my medication. Have you heard of this before? What is the purpose of this? Honestly, no. I've never heard of this before. I don't know what that means. Pill Check to review your medication. sounds strange to me. I would suggest you speak to your doctor about this as well, because the only entity I would think who would be qualified to discuss your medication with you and what is appropriate and what is not appropriate would be your treating physician. I'm not sure if that is the purpose of this website, but no, I've never heard of it, and I would want more information if I were you before I do anything like that. Question from First Time Grow on YouTube. I'm on LTD going on 2 years now. They sent me papers last month, and it said after 2 years they might or will cancel or change life insurance policy that is included in my work insurance. My question is, can they do this? I asked the insurance company and they said, don't worry about that yet. I'm not sure what this really refers to. I will try and answer it this way. If my understanding is accurate on what this question is. Quite often, when you have group coverage, in other words, through your employer, or sometimes quite often when you have private insurance as well, in other words, an individual policy, if you qualify for long-term disability benefits, there's another benefit that you may qualify for, which is linked to qualifying for a disability benefit, and it's called a waiver of life premium benefit. What that means is that you, if you do qualify for LTD, may not have to pay the premium for your life insurance any longer, as long as you qualify for LTD. So that may be what is referred to here, but I don't understand the part that it is limited or that they will cancel or change the life insurance policy that is included in the work insurance. I don't think that should happen. There may be an issue if you were to lose your employment, but it all goes back to the contract itself. If the contract does provide for a waiver of life premium, in other words, that the premium that you had to monthly pay to get life insurance coverage, that is linked to the long-term disability benefit. And if you were to be denied long-term disability, that waiver of premium benefit will likely also be affected or could be affected. So First Time Grow, if that wasn't exactly what you wanted to hear, or if my understanding of the question was not accurate, you're very welcome to reach out to us and we can look at that in more detail and see whether there is a proper answer that we can give you. One more question from Robert. And again, as you can see on the screen, go to disabilityrights.ca to contact us and find out more. Going back to Robert, I'm going to be traveling to see a member of my family for a week next month. It's still in the same province, but I will be flying there. I've asked my insurer about this, but they keep sending me to the case manager and not answering my questions. What can I do to prepare for the trip without having problems with my LTD? Good question. Many policies will have provisions that you cannot leave the country for more than a certain period of time, or you may be in jeopardy of losing your benefits. This is not that issue. This is you're traveling in the same province, but you are flying. What can you do to prevent having issues with the insurance company? Not the easiest question. So what you can do, I suppose, is it depends on what your functional restrictions and limitations are. If you're saying to the insurance company that you have significant mental health issues, you cannot leave the house, your anxiety is extreme, but then you do leave the house and you do do things that you say you cannot do, the insurance company may look at this more closely and scrutinize the claim more closely. If it is that you can only sit for 5, 10, 15, 20, 30 minutes, they're going to be wanting to know, how is it then that you're able to fly? Having said that, if it's in the same province, likely won't be a very, very long flight. What can you do to prepare? I suppose you've already asked the insurance company, you've already told them about your plans. So if it is to go visit a family member and it's just for a week, it's not for an extended period of time. Issues that they would look at when people travel would be, make sure that you continue to follow through with recommended treatment advice. In other words, that you're also continuing to be in treatment while you are away. A week obviously is not that long, but there have been cases where people have been going away for longer, for a month, for 2 months. And the question always is, are you functionally restricted and limited from performing the duties? How does your ability to fly or travel impact what you're saying you can and cannot do? Make sure, in your case, Robert, that you go see your doctor and get your doctor's support. The doctor may recommend that you need to go see your family member. It really does matter what the issue is. So get the doctor on board. You've been upfront and honest with the insurance company. Make sure that you continue to do the treatment that is required of you. And if they were to have issues with you later on, you just reach out to us. I've been approved for surgery, but this is from Bob Lawrence. I've been approved for surgery, but my insurance company does not want to meet the doctor's pay rate. So I've been sitting out for a year and a half now and nobody is negotiating. Is there anything I can do? So you've been approved for surgery, but they don't want to pay. The insurance company doesn't want to pay the doctor's rate. I'm not sure if this is referring to private coverage, because private medical in Canada, obviously everything goes through basically the public health system. If this is regards to long-term disability, insurance companies under the LTD policy, their duty is to pay you benefits. There may be rehab provisions. They may be motivated to pay for something, but only if it, in their minds, there's a cost benefit to them. So I'll use an example. If somebody is going to go through a certain amount of treatment and the insurance company may agree to fund it if the expectation is that the person will be going back to work then, versus if they have to be on claim for 2 years before they get to a point where they can get that treatment, which then obviously may cost the insurance company more. So there is no duty on the insurance company, if my understanding of this question is right, if it's regarding a LTD claim. Under the long-term disability policy, I don't believe that there is a duty on the insurance company to pay for treatment, but it may mean that the insurance company has to pay you LTD for a longer period of time. If it is that there's surgery available, if you do the surgery, that the cost benefit would be significant to the insurance company, then in those cases, they may do that. What if you are traveling for treatment in another country? Does that change the ability to travel? Sorry, just going back to Bob Lawrence's question. Sorry, we don't handle, it's a workers' compensation issue. We don't handle WCB cases, and unfortunately, I don't have the experience or the expertise to advise you on how to navigate that. I do suggest that you try and find somebody who does specifically handle workers' compensation. We handle long-term disability, short-term disability, and other coverages through private insurance companies. Odds question, what if you're traveling for treatment in another country? Does that change the ability to travel? Go look at the policy. If the policy says that you cannot be out of the country for more than 30 days, for example, then that is, it depends on what it is that you're planning. You want to get your doctor on board. You may want to tell the insurance company that there is treatment available that you're going to pursue. The insurance company cannot, they can, but I don't think they would necessarily deny a claim based on that, because if there is a cost benefit to them, that if you do travel to get better treatment that is available much faster, much quicker, then they may agree to that. They cannot force you not to travel, but they also, in my mind, would have to be reasonable in their response to you if you were to say, look, we don't think that you can travel. We're not going to allow you to travel. We're going to deny your claim if you travel, yet it is to go and get better treatment that may allow you actually to go back to work. So if they did deny your claim on that basis, I think that there is a very good argument to rebut that. And I would again suggest that you reach out to us. But go look at your policy. Get your doctor on board. Have your doctor put in writing that he supports, doctor supports, that you do travel because you're going for the specific treatment, and make sure that while you are away, you communicate with your doctor and you do continue to have the treatment that you are required, depending on what it is when you do travel. So you're welcome, Bob. That brings us to an end. This was lots of questions. I welcome these questions. Some of them were more difficult, and if I did not answer those questions properly, in other words, if I didn't quite understand the question itself, you're welcome to reach out to us and we can look at it in further detail. Our next live session is an employment law Q&A. That will happen tomorrow, May the 24th, with my partner, Samfiru, at 1 p.m. Eastern Standard Time. So join us again tomorrow. And the next time when we will have another disability law live Q&A, and I look forward to fielding your questions then. Thank you, and I wish everybody a good day.